Hi, today I'm going to talk about the case. The case has represented that a man, Michael, told Stephanie, a woman, that Ahmed, who has dated with Stephanie for 3 years, had a serious car accident and nearly died. Stephanie is shocked and begins to hyperventilate and cry uncontrollably, and then she is unconscious. However, after 30 minutes, when she wakes up in an ambulance and Albert is sitting at her side and he's pretty well. The doctor said Stephanie has suffered some form of sudden acute mental trauma akin to a panic attack. While in this circumstance, it looks similar as another case, which is Wilkinson-Dunton. In this case, the defendant, Mr. Dunton, made a mischief to Mrs. Wilkinson that her husband had an accident, and both his legs were broken, and he was lying at the Elmer's public house, which is at Leytonstone. Mrs. Wilkinson believed this news and suffered a violent shock to her system and subsequently became ill. And then Mrs. Wilkinson claimed for her psychiatric injury. On the fact, it was clear that the defendant had to be treated as having intended to induce Mrs. Wilkinson's illness, and therefore Mrs. Wilkinson's claim succeeded. And the Lord Wright stated that the defendant has, as I assumed for the moment, willfully done an act calculated to cause physical harm to the female plaintiff, to infringe her right to personal safety, and has thereby in fact caused physical harm to her. That proposition, without more, appears to me to set a good course of action, there being no justification alleged for act. Besides, the case Janvier and Sweeney in 1919 has applied to the principle of Wilkinson-Dunton. This case is talking about a private detective pretended as a police officer and threatened a woman that she was in danger of arrest for association with a German spy. He did this in order to obtain certain information about the woman's employer. The woman suffered a shock and nervous illness as a result of this statement. The claimant raised an action against the defendant, the Court of Appeal held, and applying to Wilkinson-Dunton, her appeal for damage succeed. From this case, we can find out that there are two elements required in last two cases. First, the claimant must suffer actual damage, which is physical harm or recognized psychiatric illness. Second, the defendant must intend to violate the claimant's interest in his freedom from such harm. However, there is the latest case, ONA. It's talking about a father wrote a new book which describes the sexual abuse he has suffered when he was a child. And his ex-wife opposed him to do so because their 12-year-old son has already suffered a lot of conditions and disorders. So she seeks for an injunction to prevent her ex-husband to publish the book. The Court of Appeal held this case and gave the injunction. However, the defendant then appealed to the Supreme Court, and the Supreme Court set aside the injunction and raised the three elements of the tort. First is the conduct element, second the mental element, and the third the consequence element. Until now, let's look back to the question case. Even though Stephanie has some illness and she hospitalized for 2 days, but from the doctor and the case, Sullivan and Boyle, under the rule in Wilkinson and Danton, where the claimant suffered from weight loss and required mild sedative to restore her sleeping patterns, is not sufficient as damage. That Stephanie is neither physical harm or recognized psychiatric illness. But can we claim for emotional distress in this circumstance? Well, my opinion is no. From another case, Wainwright and Home Office in 2004, this case was held by Lord Hoffman. In this case, a mother and a son went to the prison to visit her another son, and was stripped search before they entered the prison. The son brought a claim about battery because someone has touched his body unlawful, and his appeal was allowed. And then the mother suffered distress and trying to bring a claim for it. However, in here the Lord Hoffman stated that if you need to claim for emotional distress, you need to be very careful about what you mean by intent. Under the Protection from Harassment 1997, if you want to sue for emotional distress, there should be 2 or more instant harassing behavior. However, in Stephanie's case, there's no 2 or more harassing behavior in the case. From another case, Wound Parkside Health NHS Trust in 2001. This case is about the claimant Wong has been employed by NHS Trust, but she was harassment for her colleagues during the employment and resulted in physical and psychiatric harm. In 1991, he sued one of the employment for assault successfully, and after that, she raised an action against the NHS Trust and the one of the employee. However, that appeal unsuccessful, and Wong appeal. The appeal was dismissed because of her psychiatric illness is not serious as recognized psychiatric illness, but just emotional distress. And the court claimed that emotional distress is not enough. Well, from this case, I would like to claim my argument that we need to put forward a new tort, which is like intentional infliction of emotional distress. Although we already have a tort of intentional of physical harm, however, this rule tort gives strict line about the harm, about the level of the harm, which means only physical harm or recognized psychiatric illness can be liable. But just as the case I mentioned before, not every claimant suffered recognized psychiatric illness, but what they suffered also needs some statute to protect. Thank you all.